Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, petitions. Order number 4, papers. Order number 5, notices of motion. Order number 6, questions.
Member for Cherangani.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask question number 1 by private notice.
Mr. Speaker, sir, I wish to seek your guidance because this matter is actually pending before the court. Mr. Speaker, the company in question filed a civil appeal number 1008 of 2010 in the Court of Appeal and High Court civil application number 125 of 2010. Mr. Speaker, this is a matter on which the court ruled and there is judgment and these people have appealed and the same issues are being canvassed before the High Court, the Court of Appeal, Mr. Speaker.
Very well. That is a claim for sub judice. I'm wondering, do you have the pleadings both in the Court of First Instance, which in this case will be the High Court, and the Superior Court, which would be the Court of Appeal, inclusive of the judgment that was delivered, which has been appealed against? You have those pleadings?
Mr. Speaker, sir, I don't have the pleadings.
Order.
Mr. Speaker.
I have sought certain information from the Minister.
Mr. Speaker, I have a copy of the judgment which was made by the lower court, which is the High Court. And Mr. Speaker, it is also available in the website of the court. Mr. Speaker,
that may be so, Minister. You can table the judgment. But for me to be able to give proper directions, I will require all the pleadings. Pleadings, like I said, will include documents such as the plaint, which may have been filed in the High Court. You may record that. I will also require the plaint that may have been filed in the High Court. I'll require a copy of the defense. I'll require copies of any applications together with affidavits that may have been filed in the case. Then, of course, we want the judgment which you have tabled. And from there, Minister, I will want documents relating to the appeal. But in the meantime, I want to hear the member for Cherangani on your claim. May I hear the member for Cherangani first?
Mr. Speaker, I have the answer from the ministry here, Mr. Speaker, and it is not indicating or touching anything of what the minister is talking about. Mr. Speaker, the answer is here, and it is very clear, Mr. Speaker. So I will seek your intelligence, Mr. Speaker, on this issue, because the minister is talking about something different.
Very well.
Point of order, Mr. Speaker.
Order, member for Mutito. What is it? Member for Mutito.
Thank you, Mr. Speaker. Mr. Speaker, severally on the floor of this House, you have ruled that matters which are in front of the High Court or in the High Court, Mr. Speaker, cannot all be sub judice unless they touch on specific issues. If, Mr. Speaker, look at the question at hand just talks about the said drugs being zero rated not the merits and demerits of the case. Under the circumstances, Mr. Speaker, would I be in order to ask you to direct the question on the merits of whether the drugs are zero-rated or not to be dealt with? The issues which are canvassed at the High Court, unless the minister wants to tell us the issues, those ones can be left for the High Court. But if these drugs are zero-rated or not, that I think is what the question seeks to canvass. Thank you, Speaker.
Member for Central Imenti. Minister, you better take notes, listen to those concerns or expressions carefully.
Mr. Speaker, my concern is that it's become a practice for ministers to come and seek your guidance. Mr. Speaker, the reason we have the Office of the Attorney General guaranteed with the security of tenure in the Constitution is that of Chief Legal Advisor. Mr. Speaker, before they come to seek your advice, they should internally refer the matter to Attorney General and seek advice rather than come and take the time off this National Assembly by requiring you to give guidance where the law provides for the government chief legal advisor, including a Solicitor General, to advise them before coming to the House with an answer. Is it in order, Mr. Speaker, for a minister to come and seek your guidance on matters that are within their knowledge as a government, where they have a chief legal advisor in the form of an Attorney General?
Very well. Minister, you may want to respond to those points of order raised by the member for Cherangani, member for Mutito, and the member for Central Imenti, actually challenging your claim to sub judice. And Minister, before you do so, note that as the Speaker, I sympathize and associate myself with the sentiments expressed by the member for Central Imenti.
Mr. Speaker, sir, on the question raised by Honorable Kutuny, Mr. Speaker, it is true that an answer was prepared, but Mr. Speaker, looking at the issues which are being canvassed here, they are exactly the issues which are before the Court of Appeal, Mr. Speaker. Mr. Speaker, that goes to answer what Honorable Kema is asking. Actually, the issue which was at dispute was the question of whether the products were food products, which were therefore as food supplements, which were therefore not exempted from payment of duty or not. And that is the matter on which the court actually ruled. So, Mr. Speaker, it is exactly the same issue. Now, Mr. Speaker, as to whether we should be seeking advice from the Attorney General before we come here, Mr. Speaker, I think this was a straightforward case because it is a sub judice issue, and Mr. Speaker, we are ready to comply to provide all the information that you have directed me to give in respect of this particular issue, Mr. Speaker. Mr. Speaker, this is not a case which perhaps required an advice from the Attorney General, because we know that sub judice is a sub judice. Parliament is not supposed to discuss on it, and what we need to do, Mr. Speaker, is to provide all these documents which you have given me, Mr. Speaker.
Order.
And if you can give me up to Tuesday, Mr. Speaker, I will do so.
Honorable members, I'm able to give directions. Indeed, as the member for Mutito rightly said, the matter of sub judice is an area which I have constantly attended to fairly often, and that there are clear parameters within which the rule applies, as I have set out in my previous directions on the matter. But that notwithstanding, honorable members, I wish to say this, that under Standing Order number 80, any member of the House can claim that a matter which is about or being canvassed in the House is sub judice. But it is for that member alleging that the matter is sub judice to provide evidence to show that paragraphs 2 or 3 of Standing Order number 80 are applicable. And then the Speaker, in determining whether or not a matter is sub judice, will take into account the provisions of paragraphs 2 and 3. So in those circumstances, the claim by the minister for this matter being sub judice is valid. But as to whether or not I will find that it's sub judice is another matter after the minister avails the requisite evidence. It is possible, Member for Cherangani, that we may find it is not sub judice. It is also possible, and the converse is also true. So, Minister, will you please comply with the request that I have made to you to avail to the House all documents by way of pleadings, as I have particularized, judgment, and documents pertaining to the appeal from the High Court decision. The decision of the High Court which you have tabled, which is a ruling dated 19th March 2010, for the moment will not be admissible because it is a photocopy of a ruling, but it is not certified. So I'm unable to ascertain where you obtained it from. So this will be handed back to you, and you will have to have a certified copy of the ruling together with the other documents that you will bring. And I want to urge that you table those documents. Can you do so tomorrow? If you are unable, then I'll give you until Tuesday to table those documents.
Yeah, please, I will be able to do it on Tuesday.
Very well. You will table the documents on Tuesday, and thereafter I will indicate when I will make my determination. Yes, Member for Central Mint.
You have not given any, apart from expressing sympathy with the position, the point of order I raised, you have not given any ruling on whether it is proper in order for ministers to come and waste parliamentary time on issues that could be determined by the person employed by taxpayers to give that advice.
Member for Central Mint, you have made your point, but I would have thought I had said enough for a learned friend who you are, at least to the Speaker, to become aware that in fact I'm in agreement with what you say. And perhaps so that I re-emphasize it, Minister, you are under duty to seek the advice of the Attorney General before you raise a matter pertaining to interpretation of the law in the House. Because it is possible that the Attorney General, as your chief advisor, may very well tell you that this is not a matter that you should raise in the House, and you will help us to save time and therefore lead to optimal use of time, as the member for Central Imenti has rightly observed. So please do so. Ensure that you access the advice of the Attorney General, which is there for you for free. Member for Dugis.
Mr. Speaker, I stand to ask question number 2 by private notice.
Minister for Foreign Affairs.